Judiciary and Civil and Criminal Jurisprudence is now called to order. Mr. Secretary, please call the roll.
Just a second, get my cover sheet. Now mine's gone. Oh, here it is. Okay. Senators Schroer,
Here.
Gregory 15, Brown 26, Berger, May, Roberts, Schnelting. You have a quorum.
Having a quorum, we're going to go into executive session. Do I have a second? Having a second, we are now in executive session. I'm going to call up Senate Bill 1067 for executive session. Do I have a second? Having a second from Senator Berger. Open it up for any discussion on Senate Bill 1067. This is Senator Henderson's Uniform Public Expression Protection Act. Currently, any action against a person for conduct, speech undertaken or made in connection with a public hearing or a meeting in a quasi-judicial proceeding before a tribunal or decision-making body of the state or political subdivision is subject to a special motion to dismiss, a motion for judgment on the pleadings, or motion for summary judgment. This is one that gets us in line with several other states. It's a bill that Senator Henderson has filed before. Last year, it was Senate Bill 503 that we passed out of this committee, I believe unanimously, was included in Senate Committee Sub for House Committee Sub, House Bill 615 in 2025, and several other bills in 2025. And for the record, it was Senate Bill 1293 in 2024. Do we have any discussion on Senate Bill 1067? Hearing none, I now move that we do pass Senate Bill 1067. Mr. Secretary, please call the roll. Do I have a second? I have a second. Please call the roll.
Senators Schroer,
Aye.
Gregory 15, Brown 26, Berger, May, Roberts, Schnelting. 5-0.
By your vote of 5-0, you have due pass Senate Bill 1067. I now move that we bring forward Senate Bill 982 from Senator Coleman regarding the sex offender registry. Do I have a second? Having a second, we are now on Senate Bill 982. This is the act that modifies provisions relating to the sex offender registry. Instead of listing certain sexual offenses, this act provides any person from July 1st, 1979, who has been or is adjudicated as a Tier 1, Tier 2, or Tier 3 offense in the state or any other state shall be required to register as a sex offender pursuant to 589-400. Any discussion on Senate Bill 982?
Yeah,
Senator May.
yeah, so, I mean, I'm trying to figure out what's the difference, because we've passed a lot of sexual offenders bills, and I remember when we broke it down into the tiers, we are seeing,
Senator Roberts, please.
Yeah, I think with that one, the court, they were trying to go forward with the tier system, and then the court was saying because of how it was written, they were still putting everyone in like the strictest tier.
Oh,
So
okay,
this
so
is, we're fixing it.
Reclassifying.
Yeah.
yeah, because I remember when we voted to break it down into the tiers. Okay. Very good, thank you.
Any further discussion on Senate Bill 982? Hearing none, I now move that we do pass Senate Bill 982. Do I have a second? Having a second by Senator Gregory. Mr. Secretary, call the roll.
Senators Schroer,
Aye.
Gregory 15, Brown 26, Berger, May,
Aye.
Roberts,
Aye.
Schnelting. 7-0.
By a vote of 7-0, you have due passed Senate Bill 982. I now move that we bring up Senate Bill 1117, the Corey Taylor from Slipknot, or the Taylor Swift Act, I'm sorry. The Taylor Swift Act by Senator Fitzwater. Do I have a second? Having a second, we are now on Senate Bill 1117, the Corey Taylor Act. Any discussion on the Corey Taylor Act, or Taylor Swift Act? Seeing none, I now move that we do pass Senate Bill 1117. Do I have a second? Having several seconds. Mr. Secretary, call the roll.
Senators Schroer,
Aye.
Gregory 15, Brown 26, Berger, May, Roberts, Schnelting. 7-0.
By your vote of 7-0, you have due passed Senate Bill 1117. I now move that we bring up Senate Bill 1057, modifying rules on release by yours truly. Do I have a second? Having a second, it is now before the committee, Senate Bill 1057. This act modifies Supreme Court Rule 3301 to just state that the court shall give substantial weight to 4 different prongs: defendant's prior criminal history or criminal activity, any prior failure appears, the nature and seriousness of the current charge, and any known risk to the public safety before exhausting all non-monetary conditions before moving to monetary conditions. This was heard, I believe, last week? Last week. Yes, Senator May, when you were chairing this committee. Do we have any questions?
So talk to me. So is this basically is removing some discretion from the bench? Is that?
I think it gives more discretion to the bench, because currently the process is you have to satisfy all of these non-monetary conditions before you can move to conditions of monetary release. That, you know, will release you on a $1,000 bond, whatever it may be. What this says is they don't have to exhaust all of those first. They're utilizing more judicial discretion by looking at these 4 different factors. And the factors are the defendant's prior criminal history, any criminal convictions, the prior failures to appear, if they're regularly not abiding by the court, saying, here's the next court date, we need you here, the nature and seriousness of the current crime or alleged crime, and any known risk to safety to the community. Those are the things that the court shall take into account and are not required to exhaust all of these non-monetary conditions.
Okay, so I'm gonna be a no on this right now, because I'm not sure about that. I need some more information.
I'll be happy to get you that. Senator Roberts, did you have?
Yeah, I think for my notes, there wasn't any opposition to it, so no pushback from the public defenders or anyone.
Yeah, I think it was because we had a great chairwoman that day.
Yeah.
No opposition.
Yeah, but it's also a lot of may language, like they're not
Right.
required to.
So they're not required, so they can exhaust all of them? They're
Well,
not
it utilizes more judicial, so yeah, they're not required now, but if they choose to, then they can go that route if they would like.
And so you're not saying they shall go this route, you're saying they may go this route.
Right, so the
They
biggest
shall
prong-
consider,
Yeah.
but they don't have to follow.
Right. So it gives them more tools in the toolbox rather than a strict direction sheet that they have to abide by. Now it opens them up to consider different factors such as the threat to public safety, known risks with this person, a known history, a pattern in their criminal behavior.
I'll roll with you.
I would love it if you'd roll with me.
Oh my God.
Roll with me, May. Any further discussion on Senate Bill 1057?
If it was Gregory, you know I would say no.
Hearing nothing further, I now move that we do pass Senate Bill 1057. Do I have a second? Having a second, we are now going to vote on this thing. Mr. Secretary, call the roll.
Senators Schroer,
Aye.
Gregory 15, Brown 26, Berger, May,
Aye.
Yes.
Roberts,
Aye.
Schnelting. 7-0.
By your vote of 7-0, you do pass Senate Bill 1057. Last one for the day. We're going to move to Senate Bill 893 on grooming. This was the offense of grooming in sections 566, 152. Senate Bill 893 by Senator Carter. Do I have a second? Having a second, we are now on Senate Bill 893. Let me see. I know that there was a substitute distributed. Yeah. All right, let me see. I do have a Senate committee substitute ending in 0.04 on Senate Bill 893. It's 125 pages, so the sponsor and their staff sent this last week and again last night. Senate committee substitute should be in your inboxes. Is there any discussion on the Senate committee substitute? Senator Brown.
Can you go over just some of the bullet point changes on that?
Let me see if this is, I don't think we have the changes that they made. I know that they modified some of the language pursuant to Senator Gregory's
I have it if you want me to read it.
discussion. So the changes here provides that the Chief Justice of the Missouri Supreme Court shall appoint a member to the judiciary or of the judiciary with experience in juvenile court to the statewide Council Against Adult Trafficking and Commercial Sexual Exploitation of Children. It increases the age that a person must attain before being charged with the offense of grooming of a minor from 18 to 21. I think that was pursuant to the conversation with Senator Gregory, the Vice Chair. It replaces the phrase "a minor who is 17 years of age or under" with "a minor as defined in Section 573010." It removes the exception to the offense of grooming of a minor for a person that is 18 years of age or older, but not more than 4 years older than the minor at the time of the offense. It replaces the phrase "person who is 17 years of age or older" with "minor is described above." The Senate committee substitute further differs from the original version in adding provisions identical to those contained in House Bill 1814 and in House Bill 2551 relating to sexual offenses. It adds provisions relating to anti-trafficking efforts in House Bill 2273. It adds provisions identical to those contained in Senate Bill 1242 relating to crime victim assistance. And it adds provisions identical to those contained in Senate Bill 1365 relating to human trafficking awareness training for lodging and vacation rentals. And all of these bills appear to have been heard on the Senate side in some capacity in the last several years.
Okay, thank you very much.
While I'm not a big fan of the hefty bills and increasing from roughly 40 pages to 125, I think this bill will need some trimming, but I think overall it moves the goal of attacking human trafficking and grooming and pedophilia in the positive direction. Senator May.
So, given the fact that, this was dropped, and there's so many pages, I want to take a closer look at it. But due to the subject that we're addressing, I'm going to roll with you.
Okay. Well, Senator, if you roll with me, I'll likely roll with you in working on making this a little bit more concise. I know Senator Berger will too. He likes to roll with us. If you'll have him.
I know this wasn't your bill, but I remember some conversations. Senator Gregory mentioned it as well. Those concerns about a 17-year-old dating an 18-year-old. I see we're getting rid of that exception, but we're increasing the age to 21. So that should address that.
Right.
But yeah, I'm going to vote with you guys on this, but I just want to make sure it's more than 3 times longer than what it originally was.
Yeah, I share your concerns with that. I think, again, these are some really hefty issues dealing with child pornography, sexual exploitation, human trafficking, pedophilia. These are things that we must address, and I thank you all for working on such a hard topic like that, such a serious topic. But I do have concerns with how hefty this bill has become. So we're going to have to take a close look to see if there's anything that we can trim it down, because I think once this gets to the floor and gets to the House side, arguably, this could get even larger. So kind of trimming that down and making it more concise if possible. Any further questions on further discussion on Senate Bill 893, the Senate Committee substitute for Senate Bill 893?
Oh, one more. Was there any opposition to the original bill?
I don't believe we had opposition. We're going to look in the record. Senator Roberts, there was no opposition to the original bill.
Got it. Yeah, I just found that in my notes. I remember, I think, Locke, one of the prosecutors, he said I think they had some concerns with some of the language.
Yeah, and I believe that they were addressed. Yeah, it's been a couple of weeks. I believe that it was addressed in the substitute, their concerns.
Got it. Because that was the one where I think there was an exception for parents and caregivers, but they were saying that notorious case with the gymnastics
right
doctor.
The Olympics, gymnastics.
Yeah. That's coming back to me. Okay, thank you.
Any further discussion on Senate Bill 893? Hearing none, I now move to adopt the Senate Committee substitute for Senate Bill 893. Do I have a second? Having a second, all those in favor signify by saying aye. Aye. All those opposed say no. And the ayes have it. Senate Committee substitute is now adopted. I now move that we do pass Senate Committee substitute for Senate Bill 893. Do I have a second? Second. Having several seconds, thank you. Mr. Secretary, please call the roll.
Yeah.
Senators Schroer,
Aye.
Gregory 15, Brown 26, Berger, May, Roberts,
Aye.
Schnelting. 7-0.
By a vote of 7-0, you do pass Senate Committee substitute for Senate Bill 893. I now move that we move out of executive session and go into public hearings. Do I have a second? Having a second by Senator Schnelting, we're now in the public hearings. Senate Bill 996 by the Vice Chair, if he is ready. We'll start with Senate Bill 996, move to Senate Bill 1093.
Okay.
Go later.
Sounds good.
How about Senate Bill 1093? Are we ready for Senate Bill 1093?
Yes. Or no, it's not me.
That is you. Senator Roberts.
1039.
1039. I'm dyslexic this morning. No offense to those that suffer from dyslexia. I just have those moments. Senate Bill 1039 by Senator Roberts. And just for all of those, while you're getting ready, bill sponsor will have 3 minutes to present. First two witnesses, for and against, will have 5 minutes to present. All other witnesses, for and against, are 3 minutes. And as we stretch on, we'll further limit that. Please proceed on Senate Bill 1039.
All right. Thank you, Mr. Chair and members of the committee, for allowing me to present Senate Bill 1039. It establishes clear, fair, and uniform standards for court-referenced alternative dispute resolution in civil cases. At its core, the bill promotes efficiency and access to justice while preserving the fundamental rights of all parties. First, it respects party autonomy. While courts may refer cases to non-binding ADR, the bill allows parties to choose a different process, delay ADR when appropriate, or seek exemption when ADR has no reasonable chance of helping resolving the dispute. Importantly, no party is required to settle, waive discovery, or give up the right to a jury trial. Second, it strengthens confidence in the process by addressing neutrality and conflicts of interests. It requires neutrals to proactively investigate and disclose potential conflicts and gives parties and courts meaningful tools to address those conflicts, particularly to protect unrepresented parties. Third, it provides robust confidentiality provisions. ADR communications are generally inadmissible and protected from discovery, encouraging candid discussion and meaningful problem solving, while at the same time the bill includes narrowly tailored exceptions for public safety, mandatory reporting, criminal conduct, and professional accountability. Finally, it clarifies that alternative dispute resolutions are non-binding unless the parties expressly agree otherwise, and requires settlements to be in writing, promoting clarity and enforceability. In short, it modernizes the ADR procedures, fairness and transparency, and supports efficient resolution of civil disputes without undermining core legal rights. It's the same bill that I had previously presented in 2024, and it was voted out of this committee unanimously. Thank you for your time, and glad to answer any questions.
Senator, this bill has been around this building almost as long as you and I, correct?
Right.
I think it was first filed, like you said, 2020. I see 2021. I remember seeing this everywhere for several years, 2023, 2024, and last year was Senate Bill 2056. Did you make any changes to the last couple of years?
No, just
Okay.
same issues, pretty, codifying information, pretty non-controversial.
Well, I think we've we beat this horse to death on ADR, but I'll open it up to any discussion that this committee may have on Senate Bill 1039. Seeing none. First witness in support, please come forward. Make sure you have a witness form filled out. You have no witnesses. Everybody loves it. Seeing no witnesses in support, anybody in opposition? Seeing none. Anyone for informational purposes? You've done such a great job that you've clarified everybody's questions.
I think it's just so boring.
That's another way to put it.
Yeah.
Thank you on presenting Senate Bill 1039. That'll conclude the hearing. And Senator May, do you want to go? All right. Senator May's bill, it's been around for a long time, Senate Bill 945. And Senator, if you need 5 minutes, I'll give you 5 minutes instead of 3.
This is the only time you guys will get me to look up to you, okay? Good morning, Mr. Chair and members of the committee. I'm Senator Carla May, representing the 4th Senatorial District. I'm here to discuss Senate Bill 945, a pivotal piece of legislation that addresses funding for law libraries in our state, particularly in the city of St. Louis. Law libraries play a crucial role in our judicial system, providing essential resources for legal research, education, and public access to legal information. They serve not only attorneys but also self-represented litigants, students, and the general public, ensuring everyone has the tools necessary to navigate our legal system. Senate Bill 945 proposes to allow the circuit court in the city of St. Louis to charge a civil case filing surcharge of up to $20, aligning with existing provisions for our circuit courts. This surcharge will specifically support the maintenance and enhancement of law libraries, as well as other critical services. The additional funds collected from this surcharge will directly contribute to updating legal text, expanding digital resources, and improving access to legal database. Increased funding means better resources for both the legal professionals and public, fostering a more informed citizenry. Many individuals navigate the legal system without the assistance of an attorney. A well-funded law library can provide vital support through access to legal materials and guidance. This ensures our justice system is accessible to all, regardless of our financial situation. With that, Mr. Chair, I'll take any questions.
Now, Senator, this bill's actually been around longer than myself and Senator Roberts.
It has been, and it's only a $5 increase. I just don't understand the problem.
And much like your last name, this is a may, not a shall, correct?
Right.
So the court may, if they determine that they want $1 increase, a $2 increase, they can do that up to a $5. Is that correct, or am I mistaken?
No, yeah, I think you're right. Let me go back and make sure, so I won't say anything. We added the surcharge. We're just adding us to the already statute. We're just adding the circuit court in the city of St. Louis to the statute that already affects the circuit court. I think I'm right. Yeah. See, the change the fee to any amount not to exceed $15. We said not to exceed $20.
Perfect. Any further discussion on Senate Bill 945? Hearing none. Your first witness in support, please come forward. Look at this. You're gonna testify in support of her bill? Okay. Anyone in opposition? We'll just get it out there. Anyone for informational purposes? Senator May, any closing remarks on this very old bill?
No, I'm gonna trust, we've passed it out of committee before.
I think for 20 years.
We're willing to do it again.
Well, we will give it a fresh look.
And the judge always comes to testify. He just let me,
I got all kinds of problems.
All right, that'll conclude the public hearing on Senate Bill 945. We're going to move to Senate Bill 996 from Senator Gregory from the 15th.
Mr. Chairman, members of this great committee, David Gregory, St. Louis County, District 15. Before you is Senate Bill 996. This is a workers' compensation bill. We're making some changes to a lot of how the system works for our ALJs, our judges, right? So when you think of a work comp judge, they're called an administrative law judge, and they're called an administrative law judge because they're not Article III judges. So they're essentially executive branch judges. And lately, we've had some issues where judges have been accused of wrongdoing, accused of derelict of duty. We've had lawsuits over it that are very public. And so a question came down of, are these judges at-will employees? We all know what that means, at will. And so my fear, folks, is that anytime that you have a judge who has to make tough calls, tough rulings, to make them at will is dangerous, because any administration at any time, any director, any way the wind blows, our judges would then be afraid if they still have a job tomorrow. And by doing that, you're making them political. And I hope that you would support me in the fact that judges being political is a major problem. They need to call balls and strikes, and they need to do what's right, and they need to maintain the law and the Constitution, not the political winds. And that is exactly what will happen if we make our ALJs at-will employees. It is my opinion that they are currently still not at will, but my opinion tends to be semi-irrelevant to the courts. So this does several other cleanup things. The removal of judges is very difficult right now. If you want to remove a really bad judge, it takes like 5 years and multiple votes and layers. That's ridiculous. If you're a bad judge, we should be able to remove you sooner. And so we've put those provisions in place. Mandatory retirement at 70. I don't think we need 99-year-old judges walking around trying to call balls and strikes. Little things like that. So with that, I will take any questions.
Senator, a lot of these provisions have been around for some time as well, but let me just walk through a couple of these that are in the bill. The act increases, it actually increases the number of ALJs by one, correct, from 40 to 41?
Yeah, we need another one in Kansas City, so it adds one ALJ.
On the issue of aging out, that's something I talked to a lot of good judges that have aged out in St. Charles County, St. Louis County, and 70's not 70 anymore. I've seen a lot of 70-year-olds. Look at our president. Look at RFK. Look at a lot of these folks who are still rocking and rolling into their upper 70s. Would you, and even 80s, would you be open to maybe increasing that a little bit?
I am always open to discussion, Senator, so we can talk. I hear you. I'm just, you got to be sharp. You got to put a ton of energy into these decisions. They matter. They affect people's lives, and that's why I think the mandatory retirement age is a good thing. But if you want to shift it a little and talk about it, I'm happy to.
The Administrative Hearing Commission, I know when we were both back in the House, this was an issue that we saw. I don't think the Administrative Hearing Commission had met in a number of years. They weren't really active whatsoever, so any complaints that were filtering up to them were kind of going into the abyss. Do you know if that Administrative Hearing Commission has their act together? Are they have they changed course, or is that something one of your experts may be able to speak on?
Yeah, my understanding is the AHC is doing a much, much, much better job, and I mean, we have to give credit to our current governor. He's been here, he gets it, he's smooth, he's smart. I have a ton of confidence. Now, does that mean we can count on a governor like this forever? No, but I would hope that the folks vote a governor that gets it, and the AHC it plays another very pivotal role as judges, and so we've got a responsibility to make sure we get good ones.
The one thing that I think is neat about this bill, so it goes through the list of issues that the ALJ can be cited for, and they're all common sense. The ALJ has committed a felony, a misdemeanor, regardless of whether it's a criminal charge or not. The ALJ has been convicted of certain things. ALJ is guilty of misconduct, habitual intoxication, willful neglect of duty, corruption in office or incompetency, or the ALJ has committed any act that involves moral turpitude or oppression in office. But the thing that I kind of like is that you have to notify the ALJ in writing first. So the complainant has to, rather than just send it to the commission, you're actually sending them the letter that they screwed up. Do you see any issue with that?
Okay. I'm open to discussion on that too. Yeah, let's kick it around. I'm open to that.
Any further discussion on the Senate Bill 996? Any questions from the committee? Hearing none. First witness in support, please come forward. They'll have 5 minutes. Make sure you have your witness form. You can drop it on the desk and proceed when ready.
Mr. Chairman, members of the committee, my name is Randy Alborhaski. I'm a workers' compensation attorney from Springfield, Missouri. I'm also testifying on behalf of the Missouri Association of Trial Attorneys. I'm testifying in favor of this bill. I think it's a well thought out reform for the current system, which has turned out to be, well, good intended, not very practical or wieldy. So I think this as written, preserves the independence of the Judiciary, the ALJs, but at the same time gives the director the ability to remove people for incompetence and associated reasons. So on that basis, I think I can wholeheartedly support the bill. I would also point out the bill has a provision in there that allows the commission to replace attorneys who have served and represented clients who are permanently totally disabled. As an elderly or getting elderly attorney myself, I can testify that I have clients who are now who we've educated as permanently totally disabled. They're younger than me, and so they're likely to outlive me. And under the current system, there's no way to appoint a new attorney for them, transfer attorney representation. So this allows the commission to revisit those cases and transfer representation from someone like me who's retiring or going to die sometime in the next 20, 30 years probably, with someone who's younger and who can still represent these clients who need an ongoing representation. So again, I'm in favor of the bill. If there are any questions I can answer, I'd be glad to.
Well, for the record, I hope you live a lot longer than 20 to 30 years. With all of the scientific advancements, hopefully it's another 100 years for you. Maybe not. Maybe you don't want that. Okay. Any questions for the witness on Senate Bill 996? Hearing none. Thank you for your time. Moving to let's go to opposition. Is there anybody opposed to Senate Bill 996? Seeing none, back to those in favor. Please come forward and make sure you fill out your witness form. Proceed when ready.
Good morning. Matthew Smith with Associated Industries of Missouri, going on record in support of this bill. We support this bill because of the much-needed transparency and accountability for ALJ judges. With the language that implements regular audits and lists specific reasons for disciplinary actions, we believe this bill achieves this goal of improving the system for workers' compensation. Happy to answer any questions.
Matt, can you clarify on the record who you're with?
Associated Industries of Missouri.
I think this may be the first time in Missouri history that MATA, Missouri trial attorneys, not the auto dealers, but MATA and AIM are together.
Wonderful day.
Senator Gregory's making miracles here. I love to see it. Any questions for the witness on Senate Bill 996? Hearing none. Moving back to opposition. Anyone in opposition? Seeing none. Any others for for support?
Quick. Mr. Chairman, members of the committee, my name is David Oberfelt. I'm the president of the Missouri Retailers Association and a lobbyist for the Missouri Grocers Association. And yes, we also support this miracle.
I love to see it happen. Senator Gregory, and you need to go get a lotto ticket.
The miracle worker.
The miracle man, Senator Gregory. Any questions for the witness? Senate Bill 996. Seeing none. Thank you for your time. Any else in support of Senate Bill 996? I know Arnie has his witness form filled out. There you go.
Good morning, members of the committee. My name is Arnie C., ACDNOS, State Public Advocate. And I've been looking for this solution for a long time. I think that all of our judges, whether it's on the Administrative Hearing Commission or a circuit judge or appellate judge or Supreme Court judge, they all need to be on an even keel playing field. And so this bill, this Senate Bill 996, brings that to an even keel playing field. One issue that I have is increasing one administrative judge from 40 to 41 positions. I didn't get a chance to look at the fiscal note, but I would imagine it's going to be a fiscal change and probably about $150,000 to $200,000, because I'm sure that person will need an administrative assistant and possibly a paralegal. So we might be looking at $250,000 to $300,000 when you add in the salaries, the benefits, and also the pension. And so we have to slash $1 billion from the 2027 fiscal year budget coming up, and we have to slash another $1 billion in the 2028 up-and-coming fiscal year budget. And so that's very concerning that we keep growing government and adding positions. And so you might have one administrative hearing law judge, but then you need two support people to back up that law judge. The current method of the administrative law judges is kind of out of control, in my opinion. It's a good old boy system with little to no responsibility and accountability to hold these administrative law judges accountable. I believe, as I said, the same rules that apply to our circuit and appellate and Supreme Court justices must also apply to administrative hearing judges. I like the changes that are in the new statute, the reassignments, and the complaint process. I feel that if somebody feels that there's an egregious administrative law judge that does something illegal or against our statute, may do something that's unethical or a drunk driving issue, they need to be treated and held accountable like all of our other judges. I also, the chairman brought up the point about you have to first, in writing, notify the administrative law judge. I think that that's a wrong move. I think that if somebody has a complaint of ethics or unprofessionalism or violating state statute or a crime has been committed by that administrative law judge, that they should go through the same exact process that we currently have on the Commission on Judiciary Retirement and Disciplinary Complaints. And there's a form online, you fill it out, you send it to the commission reviews that information and assigns it to an investigator to investigate if there's claims to take it further. But right now, they don't have those type of things in mechanisms in place to hold them accountable and responsible. So therefore, I'm a big supporter of SB996. Thank you, Mr. Chairman.
Arnie, thank you for your time in reviewing this bill. Do you agree with me that it's a good mechanism to, if you have a complaint on an ALJ, to notify them as well, to try and stop some of these frivolous complaints? This is a nice balance in between where you're putting them on notice and moving forward with the complaints and the merits of your allegations.
I don't think that, I think that they should be treated just like the circuit judges are or other judges, where you make a complaint to the Commission on Disciplinary Action and they investigate whether there's a claim and then take it further to assign it to an investigator if there's merits. I don't like giving your claims to that administrative judge because I think sometimes it can be swept under the rug or taken care of without being documented and reviewed properly by people who don't have a dog in the fight or an angle to or an axe to grind that could look at the complaint from a non-partial process.
I bet you have a thought on aging out of judges. You've been to a lot of court hearings and you've seen some judges that have aged out that needed to age out. You've seen some who are very competent and probably could still be a benefit to the bench even several more years. Do you have any thoughts on, is 70 an adequate number? Should we increase it?
I think because of our age population with increased medicine, increased health care, we have a great health care system, I believe, in the eastern part of our state. I believe that judges should be, a good round number is 75 years. Currently, it's set at 70. I know a lot of the judges in our circuit, St. Charles County, the 11th Circuit, they have to retire in midterm, and it's kind of unfair to taxpayers or people who vote them into office. But then, like the chief judge who just recently, Judge Vegas, retired, he is now appointed to the St. Charles County Municipal Court, which he holds court a few times a week. And it's almost, I don't know if it's a full-time job, but it's probably half or 3/4 of a job. And so he's continuing on in that line of serving as a judge. But I'd like to see, I don't know how the sponsor feels, but I feel with our increase in medicine and our age longevity, I think that 75 is a good number, that they're still have their faculties, their thoughts, their thought process, and I think they could be effective and do some good justice from the bench.
Words of wisdom from Arnie Dienoff. That could be a new segment here in Judiciary Committee. Any further questions for Arnie? Seeing none. Thank you for your time today.
Thank you. Thank you.
Any further questions or those in support of Senate Bill 996? Senator Berger to inquire the sponsor.
Thank you. You were talking about age requirements Could we put something in there like at the end of their term, other than age requirements up to 75 or after 75? Let's say they run for office at 73. Would they term out at 77?
They don't have terms. ALJs.
Oh, that's right. That's
Yeah,
right.
they're, you know.
What about the circuit judges? Do they have terms? What is their term?
So yeah, it just depends. Some have to run, some don't. They do have a mandatory retirement of
At
70. Yep.
Oh, okay, thank you.
Yep.
Any other witnesses in support of Senate Bill 996? Seeing none. Any in opposition? Seeing none. Any for informational purposes? Seeing none. Senator, that will conclude the hearing on Senate Bill 996. I'm going to turn the gavel over to the Vice Chairman to move to Senate Bill 1311. And I know we have a witness coming in on Senate Bill 1393 at 9. So if we wrap up before the witness gets here, we may stand at ease for 5 to 10 minutes. But Senator, I'll hand it over to you for Senate Bill 1311. You can if you'd like.
All right, Senator, whenever you're ready.
Thank you, Senator. For the record, Senator Nick Schroer, Senate District 2, St. Charles County, presenting Senate Bill 1311. And this is a bill that we presented last year. It's a straightforward reform to Missouri's continuing legal education requirements that puts law over ideology and professional ethics over political fashion. Current rules mandate that Missouri attorneys complete an ethics credit devoted to exclusively so-called bias, diversity, inclusion, or cultural competency. Senate Bill 1311 repeals that mandate. And let me be clear, this bill does not eliminate the requirement that we as attorneys have to go through ethics education every year. In fact, it strengthens that requirement. Under Senate Bill 1311, attorneys will be required to complete the two ethics requirements, focusing on ethics as their CLEs, not on ideological re-education programs that have little to do with the actual practice of law. Ethics in the legal profession should mean honesty with the court, loyalty to the client, competence, and respect for the rule of law. It should not mean compelled speech or mandatory participation in political or social theories that have nothing to do with whether a lawyer is ethical. Missouri lawyers are professionals, not subjects of a cultural compliance regime. They should be free to choose relevant practical ethics instruction without being forced into a one-size-fits-all worldview dictated from the top down. Senate Bill 1311 restores common sense, respects the individual liberty, and keeps continuing legal education focused on what actually matters, serving our clients and upholding justice. With that, I will open it up to any questions.
Any questions for the bill sponsor? All right, seeing none, first witness in favor.
Thank you, Mr. Chairman. Members of the committee, my name is Arnie C. Acdinoff, State Public Advocate. I testified this in the last couple weeks in the House version at the Judiciary Committee over in the House. I believe in this bill. Rule 1505 of the Missouri Supreme Court mandates bias and diversity training. And I don't know if you as legislators, probably in the last few weeks, I know the House just went through bias and sexual harassment and diversity training. It's an annual, yearly grind. And all I hear from legislators over in the House especially, I don't know if the Senate's probably gone through this in the last month, but it's the same education materials, it's the same videos, it's the same speaker. It's the same grind year after year after year. I think we're all human beings. We're all good Missourians. We all know what's right, what's justified, what's ethical, what's professional. I don't know any lawyer that is biased, that is prejudiced, that is discriminatory. As a matter of fact, when they take that oath of office to uphold the Constitution and the laws, rules, and promulgated regulations, they take a serious oath, as you did as state senators, and some of you on the dais are attorneys. You took that oath, and I take it very seriously. that you're going to uphold. And I don't know any attorney that discriminates or is biased or not diversified. When it comes to taking care of your client as a Missourian, you have an obligation, regardless of their color, their creed, their sex, their orientation, to represent that client to the best of your ability. And you can't prejudice them. So I think it's a given that if you're going to get in the attorney business, that if you're going to get in the judiciary realm, that you shouldn't be biased or those type of things. So when it comes to lawyers, lawyers are all good in some areas, and guess what? They're weak in other areas. And to stand up and say, hey, I'm not so strong in this area, and I have the choice to decide what education realm I want to go through or a seminar to meet the requirements of Rule 1505, I think that it should be up to that individual lawyer's choice, because I think it's a sign of great character for them to step up and say, hey, I'm weak in this area of law. I want to take a course to better myself and to better my clients and to better myself as a Missouri attorney. And I think that giving them the choice is the best way. They should be the designation of how they want to go with their education to further their training in terms of being a lawyer. And so this is a great bill. I think it gives choice. It gives longitude to all attorneys to make their designation and make their path to be a better lawyer for all Missourians. So therefore, I'm a strong supporter of SB 1311. Thank you, Mr. Vice Chairman.
Any questions for the witness? All right, seeing none. Thank you. First witness in opposition.
Good morning. How are you, Senator? I'll set that right there. Good morning. Good morning. I'm Nimrod Chappell, president of the Missouri State Conference of the NAACP, and I'm also a practicing attorney. I spend a lot of time in courtrooms and representing people all over the state, sometimes outside of the state. I have to just start by sharing with you that part of my opposition to the bill is that there's a lot of common sense that is just not that common anymore. For example, I grew up in a very rural area, and because I know that, when I go places that are not in Kansas City or St. Louis or sometimes even Columbia, I know not to schedule a trial around Veterans Day. You know, now I love veterans, don't get me wrong, and I don't want to interfere with the observance of that holiday, but at the same time, I also understand deer season, right? And so when we talk about diversity and inclusion and equity, it's more than just the prototypical, issues that concern black people or women or any special protected category, even those recognized under Chapter 213 as needing protection. It's needed. It's needed. And the young man who spoke in favor of the bill just moments ago had some very, very good points about we are just people. And it doesn't matter whether you're a lawyer or a judge, we're just people, and some of y'all are folks of faith, as I am, and you may recognize that it's a daily path. You don't arrive at a location. You got to work at it every day. If you want to be Christ-like, you don't just get there and you're done, or you can go to church for 3 or 4 times and be done, or get baptized. The training, the educational opportunity is good. Now, if there's a course or something out there that people find offensive or don't like it, if you took it through a bar association, whether that's statewide or local or online or any of the other opportunities you have, you can fill out an evaluation and say, I don't like this, right? And you can sure vote with your dollars and just not go back. Having an opportunity to allow for ethics to be shared with lawyers in this way and judges is important. We've got a lot of case law that talks about lawyers that do 2 things, right? It's not just taking the money or having sex with clients or not being candid with the court. It is missing opportunities that they ought to have for their clients. So if you are in a jurisdiction and you need to be able to talk to people and in a way that they understand, you need to understand that sometimes the younger generation may take in information different than the older generation. That's part of this, the classes that would be eliminated. And so if you know that the average person is now down to about a 3-minute time span, then you're going to want to put some of that on video. Well, those are the kinds of lessons that are being taught in these classes. A lot of the colloquialisms that we have, and I won't name them here because some of them are offensive, we grew up with, and that doesn't make them right. But I think that people understand that if you say some of those things now, you're going to turn off your jury. You know, you may offend somebody, and that's not something you want to do in the name of your client. There are lots of opportunities to avoid that. I'd point out that in moving from 3 hours to 2 hours, that this is not reform but regression. These ethical hours are necessary to ensure that we can comply with the rules that are prescribed by the Supreme Court, the rules that govern our practice as lawyers. And as those rules continue to evolve, we should spend time learning those rules, and this is just one particular context. I think it's also important to recognize that this is the 100th anniversary of Black History Week, or month, the 100th anniversary. Missouri has made itself known for so many things. The travel advisory for the NAACP is still in effect in this state because when you travel on the roads, if you're a black or a brown person, you're more likely to be pulled over, and if, like, you're in Columbia, it's 300% more. And we just had a whole lawsuit over making sure that the data can even be accessed by people. My larger point is that there are so many inequities within the state. Those take place within the judiciary, within the executive branch, and the administration of programs, and in just our normal lives as citizens. Starting here to talk about what we need to regulate lawyers is not good. Not good. It's not going to give Missouri the right look. We're going to end up being the laughingstock again, and we ought not, you know. We've got a lot of opportunities here in the state. Let's accentuate what we can do and do those together for the people who are our clients, for the people who are in our communities, and ourselves. Thank you. I'll take any questions.
Thank you. Any questions for the witness? All right, seeing none, thank you. Is there another witness in favor? Another witness in opposition? Anyone here for informational purposes? All right, with that, any closing remarks?
Nope.
All right. Well,
no closing. I know our witnesses have parked, and they're on their way in for our next bill.
All right, so we'll stand at ease until they're here.
Okay. Mr. Chair, for the record again, State Senator Nick Schroer, Senate District 2, presenting Senate Bill 1393. I'm glad we kind of took our time on those other ones because our witnesses, our star witnesses, are here on this bill that affects them and our county so much. Essentially, what Senate Bill 1393 does is something that has been needed in our county for a very long time, and that's adding 3 additional judges. As the committee knows, St. Charles County has been growing in population, and it's been busting at the seams. We've got many issues when it comes to our jail being crowded, and I think that stems from our dockets just being slammed right now. You'll hear today from the judges in St. Charles County that the caseload is atrocious right now, and that there is a dire need for extra judges based on population and caseload. But essentially, with the costs that are associated with this and the move that we know is coming in St. Charles County, getting the public defenders, the prosecutors out of the current courthouse, we believe that kind of shifting this and allowing for time to build, with that move, build additional courtrooms and the rooms needed for judges and staff, moving this to a couple years offset would be sufficient. So this bill, even though I'm open to any of the dates, and I've talked to the bar about this, the 2 additional circuit court judges would be an election that starts in 2029, and the associate circuit would be in 2028. Again, if this committee deems that we need them faster, and I believe we do, as long as the room is there in St. Charles County, I think we can accommodate that as well. But again, the cost should be offset and evaluated by looking at the cost savings that the county would receive by expediting a lot of these cases. By expediting these cases, having more judges, you can get more of the criminal defendants out of the jail, and that is a burden on taxpayers as well. So with that, I know we've heard this bill a couple years in a row. I'd be more than happy to open it up to any questions and then turn it over to our star witnesses.
All right. Any questions for the bill sponsor? Seeing none, first witness in support.
Absolutely. Come on up.
Good morning. Mr. Chairman, thank you for the invitation. Senators, thank you very much for giving us the opportunity to be here to visit with you all about Senator Schroer's bill. I'm not sure I really have anything to say after Senator Schroer did such an eloquent job of describing the situation for you, but I'll try. My name is Chris McDonough. I'm a circuit judge in the 11th Judicial Circuit, St. Charles County. I currently serve as the presiding judge for our circuit. I also serve on the Supreme Court Circuit Court Budget Committee. I'm the circuit judge on the state's commission on retirement, removal, and discipline of judges, and I also serve on the executive council for the Judicial Conference of the state of Missouri. St. Charles County, as you all know, we're the third largest county and the fastest growing county in the state. It's been that way for a while. Growth is good, as you all know. Growth is good, but it also presents some challenges. For our court, the challenge is that we're having an increasingly more difficult time just keeping up with the volume of cases that we have to deal with. And as the old saying goes, justice delayed is justice denied. Ultimately, we all serve the same constituency, the people of the state of Missouri. And our goal as judges is to move every case, regardless of the type of case it is, as expeditiously as possible to give our citizens the level of service that they expect and deserve. We have currently 6 circuit judges, 9 associate circuit judges, and 1 probate commissioner. Of the 5 largest counties in the state of Missouri, and ranked by population, of course, those are St. Louis County, then Jackson County, then St. Charles County, Greene County, and then the city of St. Louis. If you look at the ratio of judges to population served, St. Charles County is dead last. Right now, we have a judge to population ratio of about 1 judge for every 28,667 citizens we serve. If you add the commissioner in, it goes down slightly to 1 judge for every 26,875. Of those 5 counties, again, that is the worst ratio. What that means in practical terms is that we cannot move cases as fast as our citizens expect and deserve that we move them. While almost across the board in all categories of cases over the last 5 or 6 years, we kind of take the COVID year out of that for statistical analysis purposes because there were so many anomalies. But the 6-year trend, looking back from 2019 through the end of 2015, is such that in pretty much every single category of cases, we're seeing a steady increase year over year in new filings. And what that means is that we're not able to move those cases as fast as we want. The practical implications of that are many. In the criminal cases, where we've seen really explosive growth in the number of cases that we're dealing with, the people have a constitutional right to a speedy trial, and victims have a right on the other side of the criminal equation to have their interests addressed and see justice done in those cases. We have a serious overcrowding problem at the jail right now, and our partners with the St. Louis County Administration they've been wonderful in working with us and try to come up with creative solutions to help us better manage that case flow, to move the cases faster. We're looking at a number of other things in addition to adding some judges that'll help us do that. But we can't have an overcrowding problem at the jail. That's not good for anybody. We've also seen a fairly explosive growth in the areas of virtually every kind of civil litigation. Our juvenile court is seeing more and more cases. A lot of that is as a result of raise the age, but that's not exclusively why. Just more population means more cases. So we're doing our level best to stay on top of the situation and to come up with creative solutions to help keep the wheels of justice turning that do not involve adding more judges. But in the final analysis, we simply will not be able to continue to do the work that the people expect us to do, all of us to do, without having some more help. So we are here asking humbly for your support in helping us move these cases and keep the wheels of justice turning. It's really that simple. I believe Senator Schroer's bill will help us address the short-term need and also would give us some room to grow for the next, hopefully, decade. As I mentioned before, our partners in St. Charles County government have been really tremendous in working with us. We're currently in the process of they're going to build us 2 new courtrooms in our existing courthouse. As Senator Schroer mentioned, that means we're going to be moving the county's going to move the prosecutor, public defender, and public administrator out of the courthouse, build those 2 new courtrooms, and that's probably going to happen realistically in the late 27 to mid 28 time frame. That'll give us we'll kick the can down the road, so to speak, in terms of extending the useful life of the courthouse we have now, which was built in 1993, and when it was built, the projection was that it should serve the circuit's needs for about 30 years. Well, it did. Yeah, we're 32 years now, so we're busting at the seams. So I understand full well that there's not much of an appetite in Jefferson City these days for new spending. That's not lost on any of us. We all want to be good stewards of the taxpayers' money, each and every one of us, because not only are we all elected officials who represent those taxpayers, but heck, we're all taxpayers ourselves. So I believe that this not only helps us manage the growth and stay on top of the caseload as those growth trends continue and are projected to continue well into the future, but it also we also are being good stewards of the taxpayer dollars that we're entrusted with here and back home by making sure that we are effectively, cost effectively, and efficiently addressing the needs of the courts. And the circuit courts are where the rubber hits the road. Most people who have involvement with their government at any level are going to do so through the court system, somewhere, somehow. There's probably not a single person in this room or anywhere in the state who's going to go through their whole life and not have some involvement with a court somewhere. So in a lot of ways, our circuit courts we're really the face of our government that people are going to see. We're the touch point, and we're ever cognizant of that. We are trying to do our level best to, given the resources we have, to manage those resources effectively and efficiently and deliver the level of service that Missourians deserve and expect. So that said, I'm happy to take any questions. I also have with me today Judge Erin Burleson, who's our family court administrative judge, and she'll be up next. She'll have probably some very insightful things for you to consider in terms of where the rubber hits the road in family court cases in particular. Happy to take any questions from any of you.
Thank you, Judge. Any questions for the witness? All right. Seeing none, we'll switch over. Go ahead. If there are any witnesses in opposition. All right, not seeing any, so we'll go with the next witness in favor.
Thank you.
Morning. I'm Judge Erin Burleson, and I don't have much to add except for the family court situation, which, similar to what Judge McDonough just said, we have a lot of pressure to get these cases done. Now, we don't have statutory guidelines like we might in criminal, but these people do deserve to get their custody cases or divorce cases done, and at this point, we don't have the manpower to do it. We have 4 judges in the family court, and we're setting cases. Well, I just left family court, but when I was in it, I would set 9 trials a day, and it still wouldn't really make a dent. So I don't know how much insightful that is, but it's something that, so I'm just here to represent the family court that we've been in desperate need for another judge, especially in family court, for years. Mr. Schroer was there for a while, practiced a few times in front of me, so he can also attest to it. So we just want to bring these people who are going through a pretty miserable time in their life some relief too.
Thank you, Judge. Any questions for the witness? All right, seeing none. Next witness in favor.
Fill it out.
Yeah, just the witness one.
Thank you, Mr. Vice Chair. Good morning once again. My name is Arnie C., ACDNOF, State Public Advocate. Please bear with me. I want to go through a couple issues about our growing and expanding population in St. Charles County so you get a flavor of exactly what type of growth that we're experiencing and why we need these new judges. As a matter of fact, I propose, or I want to get into some other issues and past appropriations of the General Assembly of unfunded current judge positions in the last few years. As I said, I'm in support of SB 1393. I'm also a court advocate. I attend court sessions to ensure the judges are ethical, professional, that they deliver good service to our 440,000 Good County residents. Hopefully most of them are behaving and following the laws and statutes. Not everybody is perfect, but we all strive to do the best that we possibly can. And I want to ensure that the courts are open and transparent and that the microphones are working properly, that there's no sidebars or secrets, because I believe in an open court system that's accessible to the public. Because I think when people are charged with certain crimes, I think that there's victims involved. It affects the community, it affects neighborhoods, it affects quality of life. And I think it's very important that our St. Charles County circuit, or any circuit across our state, is open and transparent. As I said, our population is growing each and every census. Currently, right now, I get a list of residential building permits from all the municipalities in unincorporated county. We are over, in my opinion, 440,000 residences, especially in the southwest corridor of our county. Duckett Creek just this year opened up a huge new sewer plant, which will service well over 250,000 additional residences. It's been constructed to add on 8 segments of expansion, and that's over on Missouri Highway N and Hopewell Road. Each week, we incur about 50 new residences that move to St. Charles County in new construction, new homes. And of course, that puts a strain on our public safety forces and our circuit court forces. There is a backlog, and I have major, severe concerns of our Department of Justice Services, our Department of Corrections. We are overpopulated, and we are renovating a dinosaur of a jail that was built in 1970, which I think should have been moved out to O'Fallon on ground that the county owns, and we built a state-of-the-art facility, saving taxpayers about half of the $150 million in renovations. Concerning to me is a payment of, in 2027, it's going to be $1,083,000, the fiscal note, and that would include a judge, administrative clerk, court reporter, but that doesn't cover the sheriff's deputy for security of the courtroom. 2028, it's going to cost $1.34 million, and in 2029, $1.35 million. Past approvals of the General Assembly in the past couple of years, there have been judge positions that have been approved by this assembly, but they have not been appropriated. So therefore, the county cannot move forward. Currently, we have purchased the St. Charles City Hall, which are going to be moving out in about a year and a half, and we're going to be expanding to that City Hall for new courtrooms. I would like to see, with the previous positions that were approved by the General Assembly but have not been funded to this date, that you approve 2 full-time circuit court positions and 2 associate circuit court positions. It's for our substantial growth, our expanding of our population. We want to send a clear message for public safety in St. Charles County, and we want to put a kibosh in bad, unhealthy conduct, and we want to preserve our community and public safety. If you recall, a couple of years ago, after COVID, we had an increase of car thefts and robberies, burglaries. Stealing of cars was the main concern. There was a task force that was formed, and we put a kibosh to people from St. Louis City and St. Louis County that crossed our bridge. We're not going to condone and we're not going to allow you to prey on our 440,000 county residents. And I think it's very important that you give the people who testified before you, our chief judge and our circuit judge, Burleson and McDonough, that you stand behind them with a firm shoulder and give them the needed tools, necessities, and employees in terms of judges, court reporters, law clerks, to do their job and to ensure public safety in our county as our judicial courts fall under the auspices of the state and the General Assembly appropriations. For those reasons, I can go on. I'm passionate about this issue. It's been dealt with in the past, but I guess the bottom line to me that I could send home and drive home to you as senators is, if you're going to approve the position, which I greatly appreciate, that's a great stance, but you have to back it up with the money and the funds to substantiate the appropriations so we can actually have an election and have an elected circuit judge and associate circuit judge position. Without that appropriation, we can't get off of base one. And so I want to drive home that point that because you may approve this position, you have to back it up in the 2027 fiscal year budget. Thank you, Mr. Vice Chairman.
Thank you. Any questions for the witness? All right, seeing none. Next witness in favor?
Yeah.
All right, I'll go back just to check anyone in opposition. Informational purposes. All right, seeing none, we'll conclude our hearing on Senate Bill 1393. And with that, I'll make a motion to adjourn. Seconded. All those in favor? Aye. All those opposed? We are adjourned.
Thank you, sir. My pleasure. It's the first time chairing a committee. Are you kidding me? Really?